Добрый день, уважаемые коллеги.
Good afternoon, colleagues.
Мы приветствуем вас на
Distinguished viewers, we would like to welcome you at the 2022 GAIDA Forum.
приоритет национальных юрисдикций.
Our today's topic is the priority of national jurisdiction. As is tradition, we hold this
Управление Ассоциации юристов России.
session together with Vladimir Gruzdev, chair of the Board of Association of Lawyers of Russia. This year, your association has provided great support to us. And we also have Ekaterina Kudelich from the Department of International Cooperation, Ministry of Justice, Russia. Good evening. Last year, we spoke about the attractiveness of national jurisdiction, about cooperation of different national jurisdictions. And given this year's focus, we are going to talk about the priorities of national jurisdictions. When we characterize a national jurisdiction, we speak about the whole volume of powers of the government and the judiciary in particular. Each and every person, not just a lawyer, has an understanding that the priority of national jurisdiction seeks to protect the interests of a citizen, of society, as well as the state, which logically stems from the interests of any government activity. The Russian Constitution enshrines one important principle, namely the primacy of national law over international law, and certain amendments have been made to the Constitution. And if international laws collide with national law, then they will not be applied. But it was criticized by many neighbors of ours as if all international agreements entered into by Russia had been severed. So why this reaction, Ekaterina? And could you tell us about this primacy of national jurisdiction over international law? Thank you. The whole spectrum of amendments to the Constitution has created a great deal of interest in international community. And amendments were introduced in the Constitution to change the balance between national law and international law. And of course, they drew a great deal of attention. First and foremost, it's the Venice Commission of the Council of Europe that paid a great deal of attention to these amendments. For quite some time throughout last year, the Venice Commission was studying meticulously these amendments. I believe the main danger, the risks that the Western community sees stems from the concern that Russia is abandoning the priority of international law as compared to our national legislation. And we were trying to dispel these concerns by any means necessary and to show them that this is not the case. I have to tell you that when the theme for today's session was determined, an emphasis was placed, and it was placed very aptly. When we speak about the competition of natural jurisdictions, we have to remember that even though the world is global and even though the pandemic has somewhat shifted that, still the world is globalized. So the efficiency and attractiveness of national jurisdiction is largely dependent on how harmonious the national jurisdiction is integrated into the world legal order. And from this point of view, the most important issue is that of primacy, be that national jurisdiction or international jurisdiction. We need to understand whether the constitutional norms dominate over international law, or is it vice versa? And the experience of last year's, the practice of last year's, demonstrate that most countries across the world stick to the following paradigm. They believe that constitutional norms still are more important than the norms of international law. To a large extent, this is due to a number of factors. Let's have a look at the Russian Constitution. It enshrines human rights and human values, and these values and principles are universal, they are fundamental. But not in all cases can we say that our values are fully shared by the rest of international community. Luckily, the world is too diverse, and that is a good thing. The aim of the Constitution is to make sure that these values in each and every country are individualized, and they have to be protected by the judiciary, by the Constitutional Court that tries to sustain this individuality and the supremacy of constitutional norms over international law. And I have to tell you that Russia does not stand alone in this assessment. In 2020, in particular, you can look at the European Union. The European Court has long a great job over the last 60 years trying to establish the primacy of European law over national law, but still last year there were 2 instances showing that 2 countries at least, Germany and Poland, were not willing yet to abandon the primacy of their national legislation over European law. Poland, in particular, as per the European Court ruling, is paying €1 million on a daily basis for its right not to observe the ruling of the European Court. As you can see, this is a steep price to pay.
Возвращаясь уже к вопросу, собственно, про вопрос о соотношении норм Конституции и международного права.
Now, getting back to this relation between constitutional norms and international law, we have to distinguish between 2 types of instruments. International instruments can be divided into 2 categories: international treaties and acts adopted by international organizations, be that rulings by international courts or agreements adopted by international organizations or international integration associations. With regard to international treaties, point 4 of Article 12 of the Constitution, it's still immutable. It says that international treaties rule over national norms of Russia. So there is not a single risk that there can be a collision between international treaties and their norms and the Russian Constitution, because there are 2 mechanisms to prevent that. First, the Constitutional Court has the right of preliminary control. It can assess whether the provisions of an international treaty that has not yet entered into force is in line with constitutional norms. And apart from that, there is also an efficient procedure, according with which the Foreign Ministry and the Justice Ministry, sometimes together, sometimes separately, they carry out an expertise of the provisions of this or that treaty, which is submitted for signing, to assess whether it can be ratified, whether it's in line with the constitutional norms. So there is little chance that if a treaty is adopted and it enters into force, there is a little chance that there's going to be a collision with the other body of legislation and with the Constitution.
закреплено вот в новых поправках Конституции, в статью 79, статью 125 Конституции.
There has been some amendments to Articles 79, Article 129, and they
Конституции. Но здесь
put to, well, they pertain to acts adopted by international organizations and their interpretation. And we tried to convince our international colleagues that the Constitutional Court that is entrusted with this important function is very cautious, very prudent with regard to its oversight function. And this is a well-balanced approach. This well-balanced approach served as a prerequisite, a premise to make amendments to that. But this was the ruling on Ochegov. This was a ruling by the European Court of Human Rights, and this ruling said that Russia had to provide the voting rights to prison inmates. The same ruling was adopted with regard to the UK, and it brought about harsh criticism because it was a very acute issue, very salient for the UK legal system. So in this particular case, the Constitutional Court has found out that if we were to adopt the ruling of the European Court of Human Rights, it would be in violation of the Russian Constitution.
Это вопрос человекоцентричности.
And, you know, we should always keep in mind the human-centered approach as well as the priority of rights of our citizens. And if we look at this ruling by the Constitutional Court, we'll see
эти понятия обозначил 4 раза всего лишь.
That
Основной акцент был
sovereignty was cited just 4 times. A special emphasis in the ruling was made on the protection of human rights as well as on proportionality of observance of these rights and their restriction in certain cases. And it shows that the human rights issue is a priority. And this human-centered approach has to be adopted when dealing with such collisions between international law and constitutional norms. Balance has to be struck between the government interests, the citizens' interests, the interests of private persons. And I think that the practice by the Constitutional Court will henceforth demonstrate that there should be no concern whatsoever that Russia is abandoning the basic principle of pacta sunt servanda. Thank you, Ekaterina. You give us confidence that there's not going to be a misunderstanding between us and our international partners. Now, over to you, Vladimir. Could you comment on that, please? Thank you. Indeed. The theme we are discussing today has been explained by Ekaterina very clearly. She has explained the position of the Justice Ministry. But the thing is, very often international bodies take politicized decisions. My colleague has cited Poland. Poland didn't agree with the ruling that was passed, and the fine continues to accrue on a daily basis, €1 million every day. And this is a colossal sum, but Poland sticks to its position, and it's absolutely normal, because that's how the principle of democracy works. Politicians are trying to protect national interests, protecting the will of the people. But at the same time, Poland sticks to its international obligations as well, and international treaties, and the same goes for Russia. So Russia joins international treaties she's interested in, we're interested in. So far, a lot has changed, starting from 1993, when the Constitution was adopted, and the amendment that goes back to 2020 created additional assurances.
понятные нормы, ну, для любого российского гражданина.
Each and every citizen
И брак.
of Russia understands that family, that marriage is a union of man and woman,
В основном законе.
and this is something we introduced into our law.
Нормальная история, когда государство отстаивает свои интересы.
So it is absolutely normal
Международных
that the government tries to protect the state interests, in particular in the national courts. Thank you. Another aspect, another priority of national jurisdictions is the internal priority. The attractiveness and the priority of national jurisdictions seek to
Деятельность государства во благо человека.
make sure that the government acts for the good of the citizen.
Необходимо создавать новые инструменты.
To make national jurisdiction more attractive, we need to create new instruments on the one hand and create new ones on the other.
Я опять упомяну поправки к Конституции,
Let me get back to the amendments to the Russian Constitution. Article
где говорится о том, что
75 Prim, which says that Russia creates an environment for
и государство
greater trust between the government and the citizens, for better economic development. And in this particular context, we should also remember a special accompanying law, namely on state and municipal oversight. Now that this law has been adopted, an important stage has been completed in the reform of oversight activities. Moreover, we believe that we are moving onwards, setting the priorities for our national jurisdiction. We are building an infrastructure for services. Yesterday, we spoke about that, and Mr. Grigorenko, Deputy Chair of the Russian government, spoke about that in detail at the Gaida Forum. So I would like to ask you, Vladimir, to dwell on that from the point of view of national jurisdiction priorities. Thank you very much. Indeed, this issue of priorities of national jurisdiction, from the point of view of how it's used to help develop our citizens, well, it's important.
То, что мы видим, что
And I can tell you,
статично и
life
законодатель,
is constantly moving.
то, что мы обсуждаем,
The executive authority, the legislative authority listen to us. And legislation is evolving, oversight mechanisms are evolving, and this is something I would like to speak about.
национального законодательства, это, конечно, создание благоприятных.
Indubitably, our national priority is to create a favorable environment so that each and every person can achieve self-fulfillment. This is an obligation incumbent upon the government. The greater the opportunities each and every person has, the higher the development level of a specific country. The more comfortable a country is for life, the greater number of citizens
Страна прирастает своим населением,
feel
своими гражданами.
better.
Развитие законодательства.
Our country develops through our citizens, and developing legislation should reflect the needs of the citizens.
Конституции
As per the Constitution,
социальное государство,
Russia is a social
создание условий
state whose policy seeks to create conditions for decent life, for equal opportunities for growth,
экономических интересов.
and also to fulfill the economic interests of the citizens. I refer to right to labor, to legal business, to implementing one's own ideas. So we see an active development of social protection mechanisms, and also we see that tools are developing to protect the citizens' interests.
За почти 30-летний
As we can see, over the last 3 decades that our constitution has been in force,
экономическое пространство, иногда даже были и
we've seen
субъектах
different
федерального государства.
types of environment. There were different taxes across different
Там, производители тех
regions, but right now it's a level playing field.
гражданин, который производит свою продукцию в
And
Тамбовской области, он может ее
any citizen who produces goods in Tambov region, you can sell them in Primorye, in Moscow, in Chelyabinsk, or elsewhere. We need the economic environment to be there, the infrastructure has to be there, logistics. has to be there, but still. I would also like to point out that the Constitution stipulates clearly that competition is a must, and also there needs to be freedom of economic activity. Private, municipal, and other types of property are recognized and protected equally. This is the legal foundation upon which our legislation rests. Oleg, you've touched upon oversight, and I can cite several examples. I am a member of the subcommission on control and oversight activities. So on a weekly basis, we study different proposals coming from government bodies and agencies. They suggest introducing different norms, that there was this decision to slash more than 12,000 norms and bylaws. Some of them date back to the Soviet times. Some of them date back to the beginning of the 20th century. They're no longer relevant. There are some absurd examples one could cite, but what is the end result? Instead of 12,000, just 147 new acts have been adopted to replace them. And there are different subcommissions working on that, and these activities are already yielding good results. At these subcommissions, we study different proposals coming from our colleagues at the federal authorities. And believe me when I tell you that our colleagues from the Justice Ministry, the Ministry for Economic Development, work through all draft documents. So documents that see no work cannot be adopted. They require careful study. And unless the subcommission has considered the document and approved it, it's not given any further movement. It's not moving forward. And the subcommission is complemented by working groups that consist of business representatives, and we see some real results now. There is an important issue related to creating a favorable environment. So how do we make our national jurisdiction attractive? How do we attract investors? We have a program on nationalization. There are very many Russian companies that have international registration, but this boils down to legal practice and also to registration. We have special economic zones established with special regime in Kaliningrad, in Vladivostok, and Ruski Island. They have already started working, but at the same time, I cannot but point out to how efficient the Supreme Court of Russia is in its legal practice. How swift it is, how swiftly it studies and makes rulings on disputes, and how much the costs have gone down in terms of fees. It's incomparable to what we used to have. It's far more cheaper, far more efficient, as compared even to many of our European partners. So this is a very good issue.
Well, I want to point out that annually, when reviewing the work of the judiciary system, we can see that the rulings and awards in favor of international companies or Russian companies with international participation total around 70%. I mean, rulings in favor of investors, foreign investors. And I must say that, well, the cadastre value is disputed quite often by Russian nationals, and 90% of verdicts are in favor of the plaintiffs. Well, Quite often, on the other hand, the regional authorities don't properly prepare the documentation rationale behind the justification of cadastre value. But, you know, administrative disputes are viewed quite swiftly, and today an important question for us to discuss in the professional community is the forthcoming changes in the bankruptcy law. Like the Justice Ministry has been quite actively handling the administrative offense code. Well, the work is being concluded. It's on the home stretch, and I hope that our colleagues, MPs, the deputies, will have their say in 2022. I must also say that the rulings, as per the rulings of the Supreme Court and the decrees and the orders of the plenums, well, are to the effect that nationals and citizens can defend their rights in their vicinity, where they live, and they can turn to court there, and they can recover fines or penalties, even from international, transnational companies and giants. You know, the global giants have to abide by our legislation. If they want to work on Russian soil, they must act in compliance with our laws, like those that protect the rights of our people, of our nationals. We have precedents, not only with respect to the judicial rulings, but only recoveries and divestitures. Another important matter is like creating an environment, a favorable environment, an enabling environment for life and for our Chinese colleagues. This is priority number one. And the leadership of the People's Republic of China now puts the growth of well-being of its people ahead of everything else, and environmental issues and environmental safety has become one of the priorities. And President Putin at the meeting and Congress of Russian Union of Industrialists and Entrepreneurs has spoken about that, saying that the requirements are becoming more stringent, and it's going to be a big market because all the emissions worldwide are calculated, and for this country this market is worth around $50 billion. Like Russia exports agricultural products to the tune of $30 billion, and we export arms in the amount of around $15 billion. But our quotas may be worth 50 billion USD, which is a huge segment of the market. It's like half of the GDP. So for us it is important to address that, to tackle that and be in the global lead, have the global lead. Well, another important thing is the sanitary protection, epidemiological protection. And the Ministry of Justice is also caring about that and thinking about that. And in closing, I want to say that the baseline principles that underlie our state are definitely protected from any external influence. The rules of international law have changed since our constitution was approved at a referendum back in 1993, but some of them make part of our legislative system. If we choose to accede to this or that international instrument or convention, it gains the priority. But I want to say at the same time that the international law should not change the fundamental nature of our constitution, and we have spelled it out in an amendment to the constitution that was approved in 2020 by the public referendum, and we want our international partners to heed the will of the Russian people and the changes made there too. This is why Article 79 appeared. In Article 79, there is a new provision saying that the decisions of intergovernmental bodies taken on the basis of international treaties Russia is a party to, but that run counter to the Russian constitution, are not applicable on Russian territory, may not be enforced. And this is about interpretation, I must say. The norms and rules of international treaties are clearly spelled out, but, with respect to application, the interpretation may differ. But, you, first of all, should be guided by the fundamental law of the Russian Federation while making a decision or issuing a ruling. So if our constitution precludes this or that international norm, definitely the prevalence of the constitution is obvious, and it is now enshrined. And what I see, like, if we compare our situation with the disputes they have in Poland, well, I think that we're quite efficient in terms of complying with our obligations. And Ekaterina has said that the Constitutional Court now has a right to give an assessment to international intergovernmental agreements with respect to whether they are in conformity with our legislation, and we should be more active in applying this norm. Colleagues, another national jurisdiction priority that, unlike the previous two, might be called exterritorial. It's not internal or external, it's something different. It's about the digital environment for the law, in line with the certificate of the federal project and the passport of the federal project of the digital economy of Russian Federation. The Economic Development Ministry came up with the concept of the machine-readable law, and that concept was approved last autumn, and it is believed that the machine-readable law may be the best norm of application of law, the best way of application of law for the sake of the convenience of the business community, the government, and the citizens, but they are complementary to the natural language norms, not superseding them. Now we have the proper environment for the machine-readable law. That is true because of the sore need, an acute need to proceed forward with this new trend, but we also need to develop our legal and economic systems, and we are well aware that with the help of machine-readable law we can resolve many of the issues that we're faced with, and sometimes, well, what is meant is the application of the AI to make a decision on the application of the rules of law and legal provisions, like the automatic fines that the AI issues and that we receive if we exceed speed or overshoot the road marks, is an example. But the common law theory says that the ambiguity criterion was passed back in 1995. We should have the uniform interpretation of the norms of the law by all the parties that apply that law. So still, we have the certainty and unambiguous nature of law established back in 1995. And the second aspect is what we think, what we deem the machine-readable law to be. Whether it is a text of a law, the text of a law that was transferred to code so that the machine can apply it and understand it and read it, or do we propose to land the code, the power, the authority of a legal act, but this machine code will not be understood by the common people or by laymen or by lawyers. Only the software developers and programmers will be able to read that. And from the perspective of national jurisdiction and like the oversight and supervision and regulation probably could be transferred to the domain of the AI, and we should make them machine readable and automate that. But if we turn to a broader analysis of the machine-readable law, we may make an inference that something similar to what I made, that we are now approaching the new review of law, because reviewing would mean the application of the unambiguous nature of law. And, we have been dealing with unambiguous nature of law for much longer than we have been handling and tackling the machine-readable law. And we can recall Count Speransky and the Soviet compendiums of laws and other practices. So, Ekaterina, do you think that is another review, or is it something brand new? Yet another review or something new? Well, I hope that the shift to the machine-readable law concept will help us recap and take stock of the huge array of laws that we have, because every person that is faced with this or that legal act starts suffering from the huge number of amendments, and same refers to the business community, because the business community needs the stability of legal regulation. So I really, really want us to switch to an ideological basis that would allow us to take stock and systematize. And for the Justice Ministry, well, I think it is going to be very relevant in terms of registration of departmental legal acts, because the Justice Ministry registers all departmental legal acts that are passed or adopted, and the grounds to accept or decline that is whether these acts are in conformity with the Russian legislation. So, and we really hope that the AI enabled solutions will help us make this so much easier and more efficient. If you allow me, I would say that the digitalization viewed from a broader perspective is important from the perspective of the international legal assistance. Like a huge number of our people were born in the ex-Soviet republics, like in Uzbekistan, and what is needed is to receive certificates and the confirmation, the justification of the job history and track record. And in normal circumstances, it took months and years, but now, with the pandemic, you can see that the execution of people's rights is suspended for quite a long while, and now we want to digitalize these queries and requests to apply AI. And this will be an effort because the international law is not fully ready for that, but I hope that the machine-readable technologies and solutions will help make people's life easier, and including international sphere. Vladimir, a quick comment. We have 2 minutes left. Well, a real-life case, an anecdote like to receive a passport, it took our people a month or two. But now with the digitalization of the civil registries and police stations and multifunctional centers, it takes only 3 days to receive a new passport. So, which is an obvious instance of the fact that naturally it is full of advantages, and when you open laws, you receive cross-references and links, and you forget all about the initial provision of the law. But anyway, the AI may come in handy, but no AI will be able to replace a professional corporate lawyer or a judge or an arbiter or a judge that hears family disputes or a notary. Because the AI gives us an opportunity to systematize and take stock of our legislation. And you can opt for very many applications that will help you file a lawsuit. But if you want to make a wish, you naturally should go to a family lawyer that knows a lot about the inheritance practices and family legislations to properly compile a will. And the deputy has already made some decisions to this effect as regards the inheritance practices, and there is an inheritance agreement put in place. So we should keep pace with the times, and at the same time us humans should hold the AI in confines, making it a servant to our needs and interests, not vice versa. Thank you, colleagues. Thank you, Ekaterina. We have had a short but very interesting discussion, and I want to wish to all our viewers that this year that is now beginning will become a year of priorities in law, and let law prevail in 2021. 22. Thank you.